Okay, here's a Midas Touch Network video put out by Ben Meiselas. There's a URL at the top there. He is an attorney, and this is about, supposedly on the Trump disqualification. And it says it's cut off, but it says 14th Amendment, Section 3. There's the full title. Professor drops major update on Trump disqualification. Who's the professor? Well, of course, it's Ben Meiselas. He's a attorney who now teaches at USC. There's a saying in the law: those who can't teach, those who can't be attorneys, teach law. I don't understand why he's on YouTube without a law firm. Okay, Meidas Touch doesn't do anything. They don't offer any solutions or have any particular platform that, is of value. Mark Elias is another one, but he has a law firm. Although I don't think he's making any money at it. Litigation is dangerous. You lose, you often end up paying the other side's attorney's fees, which can really bite. Meiselas is licensed in California. But if he was a good attorney, he'd be making buku buck, chasing ambulances, getting settlements for people in car crashes and other kinds of things, medical stuff. But if you're not smart, you're not sharp, and you lose all the time, well, then your clients might not even pay you. They might file an ineffective assistance of counsel suit and get the court to, agree that your bill isn't worth it. There's all kinds of problems that could occur. Now, Meiselas and his two brothers, Brett and Jordy, started Meidas Touch Network on YouTube. And then they got Michael Popak to join. Popak is a motor mouth, and he's pretty much the same thing. For a minute there, they had a growing list of people. They had Karen Friedman Agnifilo, who is, I guess, works with Law and Order, the New York version of TV show, as a consultant. We haven't seen any videos from her lately. She used to have Mistrial, which was 3 attorneys, and they haven't posted much of anything lately. And they had Dina Dow, who was another California attorney, who is married to another guy, Dow, who has a law firm, and she doesn't do much of anything in the law. The point is, Meiselas just gets this wrong. And here, let's just get into it. And
welcome to Professor Meiselas' classroom. We're going to talk 14th Amendment, Section 3, disqualification. We're going to give you the most thorough analysis you've ever heard about disqualification. I'm going to explain to you, while I believe personally that Donald Trump should be disqualified under the 14th Amendment, Section 3, My personal opinion diverges from what the Supreme Court ruling was back on March 4th of 2024. It was a no.
Now, this is where, he doesn't seem to understand Section 3 of the 14th Amendment, because there's two sides to it. There is the insurrection side, and there's the rebellion side. Both end up barring you from office. However, the insurrection side typically is going to always require a judicial interaction. You're going to have to go to court and prove that they're an insurrectionist. That's difficult to do because it's difficult to do. Judge Ludwig has a video out that talks about how it intermingles with free speech, and how, to reach the level of insurrection, you really have to incite force. You have to incite violence. And that's what Colorado attempted to do. They attempted to take the insurrection route with CREW, which is Citizens of Responsibility and Ethics in Washington, just like they did with the Couey-Griffin matter in New Mexico. Well, bad move, because proving insurrection on a federal level actually can only be done in a federal court. And had they really researched the law a little better, they would have found out that Section 3 of the 14th Amendment is in the exclusive jurisdiction of the D.C. District Court under D.C. Code 163501, which is quo warranto, which is the original Enforcement Act of 1870, when insurrection was a criminal matter, and then they decriminalized it. It ended up by Congress's hand in the D.C. District Court. So if you need to sue for insurrection, you have to go to the D.C. District Court. The way it's done is under Erie Doctrine. I'm not going to bore you with all that, where you bring your state law into a federal court, and it's state law, federal procedure, but the power of the federal court. They didn't do that. They just stayed in Colorado and filed under their little mandamus section against the Secretary of State. They didn't do that right, because mandamus is a ministerial act where there is nothing to adjudicate. It's just, this is what it is, so do your job. The way to have done it in Colorado would have been to take the rebellion route and say, well, he rebelled against the Constitution by violating Article 2, Section 1, Clause 1. And therefore, we have proof that he did this in the fake elector scheme and the speech on the ellipse and a number of other things where these other people are in conspiracy. And they could have even cited the Georgia case and the D.C. Circuit case. And that would have been enough under Colorado law for the judge to rule under Colorado law that federal law was violated. Then the outcome likely would have been different. But Meiselas doesn't understand that. He doesn't understand there's a difference between insurrection and rebellion. So we're going to zip around through his video because it's not worth listening to his ridiculousness. In the end, he decides that there must be new legislation before you can use Section 3 of the 14th Amendment. And he means that generally. But this case was about a state using Section 3 of the 14th Amendment to remove a federal candidate from the ballot. And the entire order is talking about that. But Meiselas lumps it all together, and he seems to think this is for all of Section 3 of the 14th Amendment. Well, those who can't understand the law teach. Now,
9-0 decision, although there were some other kind of concurring opinions that differed from the majority opinion.
And they don't matter.
Let me be very clear what the majority opinion held in the Anderson case that was decided by the Supreme Court on this issue, and it was decided on March 4th, 2024.
There's the URL at the top.
That in order for there to be a disqualification of someone running for a federal office like the presidency, Congress has to pass a law that would require the disqualification. It takes an act of Congress under the...
And this is where he's confused and he's wrong. That isn't what the order says. The order says Congress must enforce it. And in order for a state to do that, then Congress must pass legislation as to how states can do it. Okay. Then, worse than that, Justice Roberts attempts to confuse the country, confuse people, because he wants to take you off the scent. There is legislation already existing which creates D.C. Code 163501. That's the legislation that's required. Meiselas, sitting there in his pajamas, doesn't understand that there's more to it than an act of Congress. It doesn't take an act of Congress. But put that aside. If indeed this is what the Supreme Court has ruled, then understand the law order backwards. Then okay, if a state can't do that, then Congress needs to do it. And the order is pretty specific. Like at page 8 and footnote 2 refers to how Congress can do it. It doesn't take legislation, but legislation already exists again in the ECRA of 2022. So the two times that it's easy to do as an objection is if there's a private bill that addresses the issue. If Trump had gone to Congress and said, hey, I need to get off of this constitutional ineligibility, that's the word. That's the legal phrase to use. It's not disqualification. You're disqualified after the constitutional ineligibility is upheld. You take the 2/3 vote and you lose. Then you're disqualified. You're not disqualified by the act alone. You are put in limbo, which is called constitutional ineligibility. And the Supreme Court calls it that in the first paragraph of the Trump v. Anderson ruling. But he never once uses this word. So, I'm going to zip past him in a minute here, but listen to this.
14th Amendment, Section 5. Now, again, I personally disagree with that interpretation. When you look at some...
He personally doesn't understand it. So let's zip past this and just land somewhere else.
To disqualify Donald Trump. Let's just look at the opinion together. And again, this is going to be detailed and thorough. There's not going to be any gaps in this analysis. so you can.
But here's the problem. You can't analyze an order in a vacuum. That's what you're doing. You're going to read the order, and it doesn't do you any good to read the order and not understand any associated law with it. So let's zip past this some more. I have no idea where it's going to land. It doesn't matter because all of it's BS from him.
We can tell they object only to our taking into account the distinctive way Section 3 works.
Now, there he's talking about the Sotomayor and Ketanji Brown Jackson and I forget the other woman that's on there. No, Amy Coney Barrett did her own separate one, which is just a short paragraph saying turn down the heat. But concurring opinions, they aren't part of the ruling. The ruling, what the ruling says, and it stops. Any dissent or concurring opinion doesn't have the force and effect of law. So everything that these female jurists say is irrelevant. And they've misunderstood it too. No one has made a distinction that this is about a state court trying to do a federal function, because that's all it is. Crew did it wrong. They just did it wrong. They screwed the pooch royally, and they did it wrong. Here, the issue is legislation is needed if a state is going to try and do a federal duty, a federal operation against and to prevent a federal candidate from the ballot. Now, what the Supreme Court did not say is that he was relieved of the disability, but they did say Congress has that power. Only Congress can do that. They weren't blunt clear about it, but they said, Congress can do this at any time. They didn't say we can't do it, but that's the implication of the order. If Meiselas knew how to read it, he would be able to read between the lines, as they say, and see that Supreme Court is saying Congress has to do this. Now he's using the obfuscation of legislation, but that's not the only way that Congress can address this. Congress could have addressed it with a private bill. They could have picked this right up after the Supreme Court ruled and then called for a vote. And he would have been then disqualified. He's constitutionally ineligible right now because of his conduct. And the order says that too. It's conduct driven and nothing more. Then, after the vote, Trump would have been disqualified. He's not disqualified now. He's constitutionally ineligible right now. And he will remain constitutionally ineligible even if they vote to certify his votes. Then he will become an illegitimate president. Constitutionally illegitimate president. And then he could be removed by quo warranto under 16-3501. There is a amicus brief in the Anderson case, the Trump v. Anderson case, 23-719, written by Binkley. If you Google Binkley and Trump v. Anderson, Binkley amicus, it'll come up on the internet and you can read the brief. And it talks about quo warranto. If you read the brief, you'll find out that, this follows the same logic as the actual ruling. My. It looks like Justice Roberts actually wrote part of the Trump v. Anderson ruling from the Binkley amicus brief. And make no mistake, Roberts did write it. We know now. So, Meiselas is just wrong again. We're going to zip past this nearing the end of the video because he's just...
The fact that Section 5 vests in Congress the power to enforce it. These are not the only reason the states lack power to enforce this particular
Again, he's stuck. States. That doesn't mean there is no other way to enforce Section 3 of the 14th Amendment. It just means states can't do it.
So, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides.
Now, you know, this is what's wrong with just reading an order. He says they shut the door on other means of federal enforcement. No, they really don't. They shut the door on any other court without jurisdiction. That would mean only the D.C. District Court, D.C. District Federal Court, has the means to enforce Section 3 of the 14th Amendment. Justice Roberts doesn't want you to know that. And Ben Meiselas didn't do his homework to find that out. Because if he'd read the order and then read the references in the order, one of which is the Enforcement Act of 1870, and if he had read that information, he would have found out what happened to the Enforcement Act of 1870 and what happened to it and how it became 18 U.S.C. 2383. As the Supreme Court says, the bottom line is it split it. Section 3 of the 14th Amendment was originally a criminal matter. Then they split it and turned it into a civil matter. And it became part of D.C. Code 16-3501 as a civil suit. And how you bring it is a bit of art, but Quo Warranto is about who has the right to hold office. It's very easy to see how you do that. He doesn't have the right to hold office, so therefore he doesn't have the right to run. Then you go to the federal court and you prove that he has violated an article, Article 2, Section 1, Clause 1. After the court rules, and it basically has no choice but to rule, yes, you violated this, then the appeal is to Congress, not to the Supreme Court. And the Supreme Court was kind of saying that in a funky way. Congress has to do this. Congress has to do this. We can't do this. And they kept saying, they have the right to enforcement. Absolutely, they have the right to enforcement. But it doesn't mean it has to be done by legislation. So let's get to near the end of Meiselas' craziness here.
The point about them saying that 2/3 is required to remove the disability. I think that it was pretty clear, too, that the disability is the insurrection. That's what Judge Ludwig said, that the disability is the insurrection, and that 2/3 of, is required to remove that.
Now, there is just absolute craziness. He doesn't understand. The disability is the insurrection? No. The disability is the constitutional ineligibility. The insurrection is the conduct that leads to automatically the constitutional ineligibility. But on the flip side, there's also the rebellion. A Constitution of the United States and the criminal laws don't have to be proven in a court of law. It is on its face by the facts of the conduct and the public record, it automatically executes. You don't need to go to a court. It falls back on what Section 3 says. Insurrection, however, requires you go to court. You're going to have to prove that that person was involved in an insurrection. That's where it gets nasty, and that's where only a federal court for a federal candidate can make that determination. Meiselas, you look really bad, sitting there in pajamas like people don't know those are pajamas. Sitting up here calling yourself a professor, getting it so wrong, it's embarrassing. I would take the video down, but guess what? It's too late now. I've got clips of it here.
That's not what the Supreme Court ultimately held, and I went through it methodically with you right there, why it is the case, and ultimately the Supreme Court interprets the Constitution. They're the final say on this. So that's the full...
No, they're not the final say on it. The final say is Congress. The Constitution specifically says in Section 5 and the final sentence of Section 3 that Congress is the final say. Now, the Supreme Court interprets it, absolutely. And that's what they did. They said that a state cannot remove a federal candidate from the ballot. A state cannot adjudicate insurrection against a federal candidate. And all of this is because they kept trying to sue for insurrection. If they had gone the rebellion route, like Judge Luddick was saying, trying to tell people, then this wouldn't be the problem. And this is something Meiselas doesn't understand. And boy, do you look like a clown, thinking you've got this figured out. And you're just wrong. You would be hit with attorney's fees when you lose in a court. So let's just finish. We're near the end.
Full analysis, I'm sure the full analysis leaves you upset. It leaves me upset. But I wanted to go through
because you don't understand it
page with you, so you can finally see once and for all that the only path is Congress passing a bill, making it a law. And if they're controlled by MAGA in the House and Senate, it's not going to happen. We can petition.
And that's not the only path. It doesn't have to make it a law. Private legislation is with regard to a specific person, in Ray Donald Trump. Or at the joint session, they can raise it by objection. Now, there's a problem with the joint session with the ECRA of 2022. It used to be one senator and one representative could raise an objection. The ECRA of 2022 changed it into 1/5 of the members of the House and of the Senate are required in writing to be an objection. Well, that flies in the face of Section 3 of the 14th Amendment because it has no such requirement. You can't have a requirement by voting that you can use this before you can use it. No, the Constitution is what it is. It would only take one person, period. And it doesn't matter if it's a member of the public, the Senate, the House. All it would take is any American citizen in the joint session to have gotten that objection before the joint session, to call that Section 3 of the 14th Amendment has been violated, and you have information for the joint session. We're going to see what's going to happen because an objection has been sent to the court to that issue. They could be silent, they could do nothing, and after an illegitimate president is installed, if indeed Roberts will swear him in, he actually becomes easier to remove. But the Democrats aren't going to do anything, and the Republicans will jump up and down like little children. So let's finish with Mr. Meiselas' craziness. He's just wrong.
We can tell them, do it, MAGA Mike, do it. They barely could get a funding bill done. I mean, the continuing resolution. What do you think they're going to do? Introduce the bill to disqualify Trump? MAGA Mike's not going to even introduce the bill. And then when the Republicans take over the Senate, I think you've seen for yourself, we went over every page. You can go and read the full opinion. That's how I would teach this in my law class. And that's the status. In a perfect world, Trump would be disqualified. I agree with Judge Ludwig's interpretation. Anybody who thinks that the 14th Amendment Section 3 should disqualify Trump, I've said it before, let me say it again, I agree with that. The Supreme Court 9-0 disagreed, and the majority, which is the law of the land, says legislation is required. And and then there were the other judges that said, why'd you go that far? Why'd you go that far?
But that's not what they said. They said a state cannot disqualify a federal candidate. A state. That's the only thing that the order deals with. And Meiselas is acting as though it's all of Section 3 all the time. That legislation is now required, that Section 3 is now defunct without legislation. No. Only Congress can use it unless you file suit in the D.C. District Federal Court under 16-3501. Then that court has jurisdiction as granted by legislation through Congress to handle it. I would never take a law class from Ben Meiselas. He is one of those attorneys who tries to teach law through politics. Politics is how law is made. Politics is not how law is enforced. You have to know the differential. You have to see when one is not the other. He lacks that ability. And I wouldn't sit up on a video and make a fool out of myself like this. But hey, that's me. Okay, here's Ben Meiselas' second attempt at getting this wrong. Apparently, he must have seen some of the comments that basically said, you're an idiot. And he still gets it wrong. He doubles down on wrong. This is his latest one. He gets Glenn Kirshner to try and be his wingman, and they get it wrong together. This is posted December 27th, and I don't want to go through all of this, but let me just put it to you like this. There are two aspects to Section 3 of the 14th Amendment. See, he doesn't start with the basics. He doesn't understand. I don't know what law school he went to or who taught him law. You identify what you're reading. There are two subject matters of Section 3 of the 14th Amendment. It is actually only two sentences. One is Section 3 of the 14th Amendment, and the second one is about the jurisdiction of who can relieve it. Congress. Only Congress. Yet both of these bozos are talking about the Supreme Court. Maybe this will go back to the Supreme Court. You know, they got their fingers up their butt, and I'm sorry to say, I have no respect. I have no respect at all because they don't know what they're reading. Mr. Kirshner keeps talking about adjudicated insurrectionists, adjudicated insurrectionists, adjudicated insurrectionists. Look, idiot, the Supreme Court just told you that is what a state cannot adjudicate. You don't even talk about it again. And Ben Meiselas, he does the same thing. They're stuck on this adjudicated insurrectionist. Forget that. Back to the two aspects. One is insurrection. The second is or rebellion to the Constitution of the United States. Okay, rebellion is defined in 18 U.S.C. 2383, and it says any violation of an article, clause, section, whatever, of the Constitution or congressional laws. Either one of those two will activate rebellion. And then go back and plug rebellion into Section 3 of the 14th Amendment. Forget insurrection. Insurrection must be adjudicated. The Supreme Court just told you. Only basically a federal court can adjudicate insurrection. A state cannot. For a state to do that, there has to be legislation giving them some kind of federal grant of authority to adjudicate an insurrectionist. They can do it for state candidates, not federal candidates. This is not hard to understand. But unfortunately, Kirshner and Meiselas are up there like two bozos in a ping pong table. They don't get it. So let's start out with just listening to some of this crap that they're going to talk about. There's the URL up at the top. You are welcome to go listen to it. But everything they say is wrong. How this works for Congress is to take what's called the ministerial route with rebellion. Okay, forget insurrection. Even though they keep talking about insurrection, forget it. Forget all of that. It doesn't matter that originally it was referred to the DOJ on incitement to insurrection. There was no insurrection. It was a riot. That's it. An insurrection is much deeper than what occurred on January 6th. Everybody wants to keep calling it an insurrection. That's your legal downfall. That's what hurts you. That's what stops you. Okay, Judge Ludwig said so. He said, you know, an insurrection is a little bit deeper and it's harder to prove. Forget insurrection. That's what you think happened? No. What happened was Mr. Trump rebelled against the Constitution of the United States. He violated Article 2, Section 1, Clause 1, which requires him to leave office after 4 years if he's not reelected. Judge Ludwig has said so. Neil Katyal has said so. And furthermore, here's the big deal. The big deal is that's already proven. There is no court. There is no charge. There is no indictment required. The Supreme Court said Section 3, unlike other sections of the 14th Amendment, activates on conduct and nothing more. See, so stop trying to go to court. to prove an adjudicated insurrectionist. They are just completely ass backwards on the wrong scope of proving their case. Any member of Congress can just say the D.C. Circuit Court declared he violated Article 2, Section 1, Clause 1, because that's what they did. D.C. Circuit Court declared that. And therefore, we know about the fake elector scheme. So the public record is established. He is now constitutionally ineligible. He's not disqualified yet. He's constitutionally ineligible. And that calls for the vote on the second sentence of Section 3 of the 14th Amendment. Then you take a vote. Is he excused from his conduct? It takes a 2/3 majority. The Republicans can't stop this if the Democrats had a backbone. I don't think they have a backbone. I don't think the Democrats have a backbone. I think they're spineless jellyfish that are scared of not only Trump, but Trump's supporters. If 145 reps and 34 senators either vote no or don't vote at all, the Republicans will not reach the 2/3 majority required to remove the bar to office, and his votes cannot be counted. His constitutionally ineligible status will then transform into a disqualification. That's how it works. It just kind of irritates me when knuckleheads want to stand up there and say, I did this, I'm a professor, I'm a federal prosecutor, I did this, and you're wrong, and you're wrong again. So I'm going to just buzz whiz through some of this. You go listen to it yourself.
I'm joined by Glenn Kirshner, former top federal prosecutor, the host of Justice Matters. Glenn, I want to talk about this issue, disqualification of Donald Trump under the 14th Amendment, Section 3. I've seen you do some videos of it. Brian Tyler Cohen do videos of it. I've seen a lot.
And he goes on for quite a while, blah, 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 talking about himself and other people. Brian Tyler Cohen, not an attorney. He doesn't understand. He has Glenn Kirshner on quite a bit, yes. So let's just zip forward somewhere. I don't know where this lands.
Congressmen object to the electoral votes for Donald Trump because he is an adjudicated insurrectionist, but we both know.
Forget the adjudicated insurrectionist, you idiot. That has nothing to do with it. You object based on his conduct in violation of a specific article, section, and clause of the Constitution, or a specific congressional law. Forget the adjudicated insurrectionist. So therefore, ding dong, nobody's home.
No, that would contradict what the Supreme Court said can be used as a basis to
because they said, duh, you can't use adjudicated insurrection. A state cannot adjudicate insurrection. Why does he not understand this? Maybe he's getting too old.
disqualify someone. But if they do it, does it bubble back up to the Supreme Court? Do we try to force the Supreme Court to revisit?
Can he not read? Section 3 of the 14th Amendment, final sentence, lays jurisdiction to Congress. Congress has the final word. And if you read the order, the Trump v. Anderson order, the Supreme Court tells you that. It tells you Congress has the power to address this, and they can do so at any time. Most of it's on page 8. Between page 7 and page 8, a lot of the rest of it's word salad. You know, these people are irritating because you know what they're doing? They're not doing the American people any favor with their ass backwards, dumb crap, thinking that's kangaroo legal analysis.
It's ruling / dicta. I've heard it argued as both things. I don't know. These are things we can.
You know, these people find a way to just talk about. So I've jumped 3/4 of the way.
The Supreme Court did not disavow or undercut the fact that he is indeed an insurrectionist. I mean, I think we have to lean forward as far as we possibly can, tactically, without falling flat on our face and breaking our nose, in order to find ways to fight the righteous battle. But I have to agree with you that in the event any of this ultimately goes back to the Supreme Court, whether they deem this a political question, justiciable or not, let's assume it goes back to the Supreme Court after January 6th. What do we think the Supreme Court is going to do? They're going to say, well, just like we told you back in March, you need implementing legislation from Congress.
And that's not what they said. They said a state needs implementing legislation. They didn't say Congress needs legislation. They said the opposite. That Congress has the ability. And at page 8, referring to footnote 2, they specifically say Congress can create special legislation, for determination. What do you think the ECRA of 2022 is? It's legislation under which you can make an objection. Now, the problem is they want 1/5 of the members of the Senate and the House to make the objection valid. Well, that's unconstitutional. That's unconstitutional, and a federal court may weigh in on that very soon. That's unconstitutional because you can't have an agreement to allow the Constitution to be enforced. That's just bass backwards all the way. One person, whether it be a congressional member or a member of the public who properly raises the objection, activates Section 3 of the 14th Amendment. It activates on conduct and nothing more. No need for indictment, no need for a charge, no need for a judge, no need for a court. And the Supreme Court has told you in a funky kind of way, we don't have jurisdiction. But we can tell you a state cannot do this. In order for a state to do this, there has to be legislation. Well, we're not in a state anymore. The state is not in this anymore. These people have got their heads up their butt because he's talking about we need to find a way for the good fight. No. Not with your head up your ass. No, you won't. So that's 3/4 of a way through. I don't even want to listen to Mr. Meiselas because he's just ridiculous. Let's see what the final thing is he's got to say.
Express language of the Constitution in any number of ways. And one of the very difficult questions to answer is, what can we do? What should we do when the Supreme Court abuses its discretion? And I don't know if we're going to end, but, I'm always looking.
Okay, what we do there is existing legislation that has jurisdiction over the Supreme Court justices. It's known as DC Code 16-3501. And if you can find a way to show how they've overstepped the Constitution, then you file quo warranto on them. And that will remove them from office. Don't get up on a video and start talking and not know what the hell you're talking about. Because that's what this is. This is embarrassing. If I was either one of these attorneys, I would just be embarrassed. Especially when someone just called me clean out, showed me how effing stupid I am. Let's see what else he's got to say.
For a little bit of optimism and a point of light. But listen, the Supreme Court gets stuff wrong. Look at Plessy versus Ferguson, right? The horrific, separate but equal.
Okay, no need to talk about that. You know, stop filling space, filling time. The Supreme Court did not get this one wrong. What they wrote was an order of statecraft to confuse you, and it worked. They wanted to throw you off the scent of how to do this, because there are two aspects to Section 3 of the 14th Amendment. One is insurrection, the other is rebellion to the Constitution of the United States. And rebellion, as I said earlier, is defined at 18 U.S.C. 2383 as a violation of the Constitution, you know, any kind of dereliction of duty under the Constitution, or congressional laws. Now, let's not get all, deep into weeds with the congressional laws. But that is a rebellion to the Constitution. The Constitution and the laws of Congress are taken as a whole the law of the land. So a violation of the Constitution of the United States is any violation of any congressional laws, not state laws. Not state laws. That's why the Colorado case does not work. Those are state laws. You cannot declare him, adjudicate him an insurrectionist under state law as a federal candidate. I don't know why these two bozos cannot understand that. Let's finish it up. And
government sanctioned, government sponsored racial segregation. That was 1896. They decided it. It took 58 years to make it right with Brown versus Board of Education, which kind of
totally unrelated, because that was racism. This is a plain constitutional issue that you and Meiselas and a few other people can't see. Neil Katyal sees it. Judge Ludwig sees it. They're just quiet. Lawrence Tribe sees it. He's quiet. They're just quiet because there's only one way to get this done, and that is to file a petition for a writ of mandamus against some member of Congress who's indicated that he or she is going to go against his oath and duty and fully knows it. Now, many people in Congress do not have law degrees, more so Republicans than Democrats. But the Democrats who do have law degrees, they're not getting it either. And the Mr. Maine constitutional law professor, Jamie Raskin, I'm not sure if he just doesn't get it or if he's just scared. I think he's just scared. They don't have protection details. They don't have Secret Service. He doesn't want some Trump supporter popping out of the weeds shooting him. I think he knows how this could work. And I'm sure that Congress has been set ablaze on how it should be done, because that's what they're talking about here. Congressional members are asking them, well, what about this? Well, what about this? We're getting this from people and members of the public. You notice, they don't tell you anybody who's putting forward these plans. Why are you talking to us? Why are you talking to the general public? Why are you feeding the general public the wrong information? As they say, F you. Okay, it's a bit hard to find. That's what searched on. Binkley amicus brief, Trump v. Anderson. And I believe this is it here. 33 pages. And this is directly from the Supreme Court. There is the URL at the top. You probably can't see the whole thing, and there's nothing I can do to bring it up. But this is the brief of Ryan Binkley for president, law firm. And here's the question presented. In his amicus brief, he cites D.C. Code 163501, along with the Federal Declaratory Judgment Act 2201 to 02. And he says, you know, that's enough jurisdiction right there to issue a writ of quo warranto, although it says warranty, somebody just had a typo, against a disqualified president or president-elect. So basically this brief is saying exactly what I'm saying. You can object to him under Section 3, or you can issue a writ of quo warranto against a disqualified president. Now, he would be disqualified if his votes are counted and there was no vote under the final sentence of Section 3 of the 14th Amendment. But he's trying to say Section 3 of the 14th Amendment doesn't apply at all. The brief goes on. There's a table of contents, blah, blah, blah. But if you read this brief, it is eerily similar to the actual ruling. And it starts out, if we get past these tables, he admits he's running for president. It's not clear what happened to him, but he was a Republican challenger to Trump. And he goes through a whole lot of stuff about how they're not treating him right. But here's the summary of his argument. He says D.C. Code 16-3501 is a congressionally enacted federal law applying the writ of quo warranto to national officers, provides exclusive jurisdiction to the U.S. District Court. So when the Supreme Court said we don't know of any law that addresses this, well, it's right here. It's right here. But they don't want you to know about this because they want to throw you off the scent. And, this basically says even though Trump might get his votes counted, he can be removed by a simple federal judge and a jury. So if he doesn't get the vote, if they don't take the vote and they certify him as president, he's an illegitimate president. You'll notice that Mr. Meiselas and even Kirshner, they don't seem to know this exists. It talks about Article 2, Section 1, Clause 2. And here is the legal theory. You're welcome to pull this up and read it yourself. But this is where this brief is one of many submitted. This is the only one I read that says this: disqualifying a president-elect, even a future president-elect, i.e. a presidential candidate, is a federal power that could only be exercised by the federal government after the presidential candidate is elected as president-elect. So he is saying Congress has to do this. If you read this brief, you're going to find it is eerily follows the actual Trump v. Anderson ruling. It says states are preempted from disqualifying presidential candidates from their presidential ballots because the D.C. Code 163501 already provides exclusive jurisdiction to the U.S. District Court to issue a writ of quo warranto against a disqualified president-elect. A disqualified presidential candidate is elected under federal law. The disqualification procedure occurs after the presidential election in the U.S. District Court. So he's using the wrong language too. It's constitutionally ineligible. But he calls it a president disqualified president-elect. It's semantics at this point. If you read this, this is the first part of the brief, and then after that it goes into a whole lot of other stuff. But basically he's saying states cannot disqualify presidential candidates. So what's happening is, even though he's a Republican against Trump, he's arguing for Trump. Don't know why. But here are the requirements: that you be a natural born citizen, 35 years of age, and 14 years of residency. And those exceptions do not apply. So, next up is the second attempt of Mr. Meiselas with Glenn Kirshner, again harping on adjudicated insurrection. There's just no good way to say it. It became a national word, and everybody, it just falls out of their mouth, like crap out your butt. And stop with the insurrection. Just stop. There was no insurrection. Colorado cannot adjudicate him an insurrectionist. And while they can, if he was a state candidate, they can't qualify him an adjudicated insurrectionist for a federal position. State court cannot make federal law. And that's what this brief said, and this is what the Supreme Court ruled, and it seems to have come directly from this brief. Maybe Kirshner and Meiselas should do a little research before making a video chasing those Google advertising dollars, because they're not doing the American people any favors. Well, let's start out with the fact. The official fact from Congress.gov on the Constitution as to Section 3 of the 14th Amendment with regard to the Trump v. Anderson case. Everybody wants to call it an insurrection. Well, that's where they go wrong. Immediately they hang on to the insurrection. Insurrection. It was not an insurrection. It was a riot. He did incite a riot. He did incite an insurrection, but the insurrection didn't happen. It didn't get far enough to be an insurrection. Incitement to insurrection was what Mr. Trump was charged with in the second impeachment. It failed. However, it remains. When charged with insurrection, you are automatically barred from holding office. That's not something most people notice in how the law is written. You have to be acquitted once charged, because insurrection or rebellion, both under Section 3 of the 14th Amendment, only require that your conduct be identified, that there be a public record that it existed, and under Section 3 of the 14th Amendment, it automatically attaches. However, we must be clear. A state cannot adjudicate insurrection. He took the wrong route trying to adjudicate insurrection. Forget the insurrection. Leave the insurrection issue alone. It is not the way to go. The way to go was rebellion. And there is an annotated thing here that basically explains that. It says, states cannot determine a candidate's eligibility for federal office under Section 3 of the 14th Amendment. That's the long and the short of it. Period. So that meant a state court cannot do that. And Anderson v. Griswold was the base case. And the state determined that he was disqualified from holding office. Well, no. The disqualification actually occurs after the vote by Congress. They sent the appeal to the wrong place. Had they sent the appeal, insisted the appeal go to Congress, and Congress then voted and did not reach the required 2/3 majority, then Trump would have been disqualified. But what did they do? The Colorado Supreme Court sent it to the U.S. Supreme Court, who had no jurisdiction. They're telling you in their order they had no jurisdiction. Their grounds were he had engaged in insurrection. Okay, they don't mention rebellion anywhere in there. They don't define his conduct that is a rebellion. They don't define how the public record shows that he was in rebellion. And they were in the wrong court. This whole Colorado thing should have been brought in the D.C. District Federal Court. That is where the legislation already exists for it to be heard. Blame crew. Who brought the suit? They did it wrong. They did it the same way they did it for Couey Griffin in New Mexico, who was a state officer. That's why it worked there. All right. They told the Secretary of State couldn't put his name on the primary ballot. Well, Section 3 of the 14th Amendment does not speak to the ballot. It speaks to ineligibility to hold office. He would have until Electoral Count Day to clear that ineligibility. And here's a point that must be made. The constitutional ineligibility, which is the term that the Supreme Court uses, it's in the first paragraph, that attaches on conduct and conduct alone, nothing more. So when the D.C. Circuit Federal Court, the Court of Appeals, D.C. Circuit, declared that Mr. Trump had violated Article 2, Section 1, Clause 1, right then is when the constitutional ineligibility attached. On January 6, 2025 is when Congress is obliged to vote, and Trump must reach a 2/3 majority in both houses, or his votes by law cannot lawfully be counted. This annotated reference refers clearly to the Supreme Court's reasoning that Section 5 grants Congress alone the authority to provide for the enforcement of Section 3 against federal officers and candidates. It does not, however, say that Section 5 must be used. It says it grants Congress alone the authority. Now, it closes by saying the court noted, however, that states retain concurrent authority to enforce Section 3 with respect to state offices. So in that respect, the Colorado ruling stands if Trump tries to run for any state office in Colorado. So it's still valid. But it's just that the adjudication does not cover federal offices, federal candidates. A state cannot determine that. What they needed to do was turn around immediately and file in federal court. They didn't do that. Justice Roberts made a mockery of Jason Murray, who was the little snot-nosed attorney who was arguing the case, and asked him, how's it work? How does it work? In oral argument, to prove that Jason Murray didn't know what he was talking about. Now we have Ben Meiselas, and then Ben Meiselas with Glenn Kirshner, both of them trying to argue the insurrection route. There are two routes in Section 3. One is insurrection, the other is rebellion. Rebellion is a ministerial path. Insurrection is a judicial path. The judicial path is hard and dumb. The rebellion path is easy and ministerial. Find the conduct alone, prove it through the public record, it attaches. That is what the Supreme Court said. It said Section 3, unlike other parts of the 14th Amendment, attaches on conduct alone, nothing more. That means no judge, no court, no indictment, no ruling, nothing is needed. However, for insurrection, the conduct must be proven. for rebellion, the conduct simply need be identified as violating an article, section, and clause of the Constitution or a congressional law, because it's identified in 18 U.S.C. 2383, which Supreme Court also makes note of in the Trump v. Anderson ruling. It's actually illegal in most states for people without law degrees and licenses to practice to give public advice. And you have to be very careful about speaking about the law to influence others. Now, Jessica Denson on Lights On, she's not a lawyer. Brian Tyler Cohen, not a lawyer. David Pakman, not a lawyer. Many of these YouTube content creators are not lawyers, but they step regularly over the line in interpreting the Constitution legally. What I'm telling you here is what it reads, and it reads two routes: insurrection and rebellion. It reads that rebellion and insurrection are defined at 18 U.S.C. 2383. The Supreme Court in their order says that. If you just read it. If you just read it and you know how to read past the garbage that's in it, then you understand why they say legislation is needed in order for a state to be able to adjudicate an insurrectionist for a federal candidacy. See, and they try to say all the detailed ways that it's required for it to be valid for a state to be able to do that. Everybody's just so angry they can't read the words. The Supreme Court did not get it wrong. They confused people. They intentionally confused people. But that's not unconstitutional. Unconstitutional has to do with justice, domestic tranquility, and to form a more perfect union. They did not unjustly rule. They ruled as clearly as possible to promote domestic tranquility. And to form a more perfect union, well, you just can't please everybody who won't read what they wrote. It's very simple. They've put no limitations on Congress, on how Congress may enforce this. They don't mention rebellion pretty much at all, other than in the definition, insurrection or rebellion. They don't define it. They don't define how to prove it, because that is not what was argued. What was argued was insurrection. Kirshner and Meiselas get it wrong. Kirshner gets it right one time where he says it doesn't speak to the ballot, it speaks to inability to hold office. But then they both get it wrong because they start talking about disqualification and adjudicated insurrectionist. Irrelevant. Right now, Trump is a constitutionally ineligible candidate with enough votes to win. Technically, Congress has a duty to call the vote based on, and somebody needs to raise the point of order, based on the D.C. Circuit Court of Appeals ruling, which declares that Trump violated Article 2, Section 1, Clause 1 That's the rebellion. Those are the magic words that put Trump in constitutional ineligibility. Okay, Ben Meiselas, for the third time, is trying to present his bass-ackwards position on Section 3 of the 14th Amendment. And then along comes the Hill, which contradicts him. And then he gets Harry Litman, which is coming up after this, but I'm not going to play the full thing because Litman doesn't have a clue. Litman doesn't say anything legal about a position on this article or the law. But this article is fairly clear on how it's supposed to work. This was posted the day after Christmas, 12/26 at 8 a.m. There's the authors, and it's the Hill. Now, I'm not going to talk about the beginning of this, but we're going to skip right to the part where it says that they're wrong. Some argue blah, blah, blah. This view lacks merit for 3 reasons. Okay. The first is the majority's suggestion that there must be new implementing federal legislation. Bunk. But there already exists legislation. It's in the D.C. Federal District Court. So let's just skip right to the meat. Crew brought the case in the wrong court. Okay? It may have been Colorado law, and that's fine. But when you're dealing with a federal question, you bring it in a federal court using state law, claiming a federal question as to why it's in federal court. In many places, it's called the Erie Doctrine. Federal procedure, state law. In this case, the state law was basically a mandamus law. But instead of doing that, what did they do? They had an insurrection trial. Okay, no, wrong thing. Ben Meiselas doesn't address any analysis of what happened in the case, and I'm pretty sure he doesn't understand it. Now, this Hill article has several links to things like what lawyers call dicta, and it'll take you to a definition or something like that. You can spend your time doing that if you want. I don't know where they get the holding that Section 3 is not self-executing. May be an alternate holding. The court didn't say that. The court said the opposite. The court said Section 3, unlike other parts of the 14th Amendment, is conduct-driven. It says that when you take a qualifying oath and you do something that violates that oath, the bar to office attaches, and nothing more. Okay, that's self-executing. The Supreme Court has defined it as self-executing. Now, it talks about an overreach is a power grab which Congress is not required to credit. I don't know what they're talking about. However, it's not an overreach. The difference is you're talking about state court power versus congressional power. The Congress has the power to enforce Section 3. it may do that by enacting legislation and handing it off to something else, which it did do. And mysteriously, the Supreme Court acted like they didn't know about this. It's in the Binkley brief, Binkley. It specifically talks about how Congress has already granted exclusive jurisdiction to the D.C. District Federal Court. That is the court where this Colorado case needed to have been filed if you're going after a federal candidate. It could have been filed in quo warranto, but not necessarily. It could have been filed preemptively. The Binkley brief says it has to be filed after he wins the election. Well, that's not true either. But if you read that brief, it says that if he's sworn in and the Section 3 of the 14th Amendment vote is not taken, clearing him of the disability, then he is an illegitimate president. He can be removed by quo warranto. Read the brief. It was previous to this. Then it goes, second, the Electoral College votes are a matter uniquely assigned to Congress. See, so when Congress does this, guess what? The Supreme Court will have no jurisdiction. Whether Congress has the chutzpah or the balls to do it, I don't know. I don't think so. Then third, specific legislation is designed for this situation already exists. The Electoral Count Act and the ECRA of 2022. The Electoral Count Reform Act, which is the ECRA of 2022. And it tells how you use it to file an objection. Okay, you can make an objection based on Section 3 of the 14th Amendment. The problem is the ECRA of 2022 requires 1/5 of the members of both houses for the objection to be valid. That's unconstitutional. A court may weigh in on that sooner than you think. The Act specifies 2 grounds for objection, and it talks about them here. One is where the electors were not regularly given, and a vote for a candidate disqualified by the Constitution is plainly in accordance with the normal words, not regularly given. So, if you're not qualified in terms of what the Constitution states, which is age, citizenship from birth, and 14 years residency, then you're disqualified by the Constitution. But right now, Trump is constitutionally ineligible because he has violated Section 3 of the 14th Amendment. Then it goes on to make an objection under the Count Act requires a petition, and it's signed by 20%, which is 1/5 of each house. That's what I'm maintaining is unconstitutional. Now, you can go read this article yourself, and you should. Because listening to people like Ben Meiselas, who he just gets this all wrong. Now he's talking about MAGA Mike Johnson won't cooperate. Ben Meiselas can't count. 2/3 the vote of both houses are required to overcome the Section 3 of the 14th Amendment violation. The Republicans do not control 2/3 of the votes of both houses. So the Democrats can take a stand with, as I've said before, 145 reps and 34 senators will keep the 2/3 majority from ever being reached. Now, this is the end of the article. It identifies the authors, Evan Davis and David Schultz, and these are constitutional scholars. They both clerked for just, someone in the law. One was a chief, as it says, of the Columbia Law Review, and the other was editor-in-chief of the Yale Law Journal, and both clerked for Justice Potter Stewart. And Davis is a New York lawyer, and Schultz is a Chicago investment banker. It doesn't say if he surrendered his license to practice or not. However, let's move on to briefly what Ben Meiselas is talking about with Harry Litman. Now, he just got Harry Litman on. I'm not clear if they're paying these people to appear or what, but Litman says absolutely nothing. He says absolutely nothing regarding, he just agrees with Ben all the way through. So, that's Ben Meiselas BS. He's wrong. Ben is getting more and more agitated because everybody keeps telling him he's wrong. And people who are actually constitutional professionals are telling him he's wrong. And he keeps saying, I don't read it that way. You need this and you need that. He can't differentiate the fact that what Congress does is what Congress does. What the case was about in Trump v. Anderson was about state power. The two are not related. Not at all. Not in any way. Okay, here is the latest Ben Meiselas post to Meidas Touch. This was posted December 28th. There's the URL at the top, as was the URL at the top of the Hill story. You could go back and look it up. You can also find it, just by searching that partial URL, and usually Google will bring up the entire story. I couldn't, it doesn't fit in the URL window, and there's no way I could manipulate it to show it. But here's the one from Meiselas. Court at war with itself. What the F is he talking about? The court is not at war with itself. There's a difference between the state and Congress. Meiselas is so confused, he acts like his confusion is clarity. It absolutely is not. That's the total name. Here is the date it was posted. And let's jump in to begin. I'm not going to let it go on for long because he says nothing.
I'm joined by Harry Litman of the Talking Feds YouTube channel, Talking Fed podcast, and Talking Fed Substack. Harry, I want to talk about the most productive use of the pro-democracy time, the lawyers, constitutional scholars, in pushing back right now against Donald Trump's agenda. And I want to get your views and perspectives. You're a former top federal prosecutor, law professor, scholar. I think it's critical that we know what you think is the most productive use of time right now. I mean, there's been a lot of talk right now about the 14th Amendment, Section 3 disqualification issues, which unfortunately I thought was resolved wrongly, but resolved.
Okay, the only thing wrong here is you, Meiselas. And the fact you're just sitting up there all red-faced means I think you know you're wrong. And you're reaching out to other people to try and get them to agree with you. Now, Harry Litman, both of you are supposedly law professors. That is absolutely no respect whatsoever. It just means you can't be a lawyer. It just means you don't know what you're talking about. Now, Harry Litman, I'm not gonna waste a whole lot of time with him. He says absolutely nothing about the complexity of the issue, and nor does he try to define it. I'm gonna just zip to the middle somewhere, and let's see what's happening.
Was a head scratcher. Would it be, for example, you had, a trial court in Colorado say, Seems to me he committed insurrection. There are factual issues, right, to have to go over. Would that do it? What about, if
Duh. A trial court in Colorado. It's not a federal court. Not a federal court in Colorado. And this is where they don't understand. If you look at the Binkley brief, Congress has already enacted legislation in several places. The one being the D.C. District Federal Court is where all issues about federal candidates and their abilities to be constitutionally eligible are tried. That's what it's all about, because the Section 3 of the 14th Amendment, which was originally enforced under the Enforcement Act of 1870, which was originally a criminal type of case, turned into a civil matter. It was decriminalized, and it was moved into the D.C. District Federal Court for all things federal. You're in the wrong court if you're in Colorado. Littman doesn't know that. Let's zip along somewhere else.
Is that you have to remove the disability, to which I say to those people, I agree with you. I read it. I understand what it says.
No, you don't.
All I'm trying to say, and I think what you're saying and others are saying, is why Judge Luttig said it was an abomination is because you do have pretty clear language in the 14th Amendment, Section 3. Perhaps the drafters of that didn't anticipate a situation like this. They were dealing with the post-Civil War situation and trying to use this as kind of...
Judge Luttig said it was an abomination because it doesn't make clear that this is for state court issues only. It doesn't make clear that Congress still has this power and that this is where it's brought in Congress. That's why page 8 has the most of the meat of the ruling, but it has also a reference to footnote 2 on page 8 of the Trump v. Anderson case, which basically says that Congress can even do this post-election. And we're talking about Section 3 of the 14th Amendment. What is wrong with this guy, Meiselas? He is an absolute legal idiot. There's no other way to say it. Once he's stuck on seeing it a certain way, this is the kind of guy that will lose in court and get hit with all kinds of attorney's fees for just being stupid. Littman doesn't say anything all the way through. You can go watch this, but I'm telling you, the guy's wrong. Let's zip further.
this is in some ways as clear as somebody being 34 or not being born in this country, and that it wouldn't take the whole apparatus that you're saying. But this is different, and I'll just say, frustrating though it may be, constitutional lawyers are familiar with the idea that there can be a clear violation and yet nothing to be done about it. And for whatever reason, that's the posture we're in. And so you're right, man, oh man, rather than tilting it with...
I don't know what he's talking about. Because at one point he says what the issue is. It's as clear as someone who is not 35 or been in residence 14 years. Once the constitutional ineligibility attaches. And further back here, he talks about how Jack Smith should have sued under 18 U.S.C. 2383. But what they don't understand is everything doesn't require a judge. If you charge someone under 18 U.S.C. 2383, you're charging them with incitement to insurrection. You're charging them with incitement to rebellion, or you're charging them with rebellion. It depends on what the rest of the indictment actually says. But if at some point in there is enough public record to prove that this was done in a form of a rebellion to the Constitution, there is no judge required. It attaches at that moment. It does not require the trial even finish. The thing could have been dismissed just like Chutkan's was, and the thing would still remain as the D.C. Circuit Court of Appeals ruling says that Trump violated Article 2, Section 1, Clause 1 in minimum. Now, there are 20 other objections that under Section 3 he's also violated. And these two can't figure out how Section 3 is used at all. It's just like Judge Justice Roberts asked Jason Murray, how does it work? How does it work? He asked him that in the oral argument to prove that Jason Murray didn't know what the F he was talking about. And he didn't. Well, that's what you have here, Mr. Meiselas. He doesn't know what he's talking about. And Littman is just trying to weave in and out, not saying anything, not making any committal whatsoever. I can't respect either one of them. When you become a law professor, you're not a lawyer. Because you don't know how to argue. You don't know what the heck you're talking about. Meiselas hasn't got a clue. Let's zip near the end.
And I think you are living proof that you can convince, at least push back with the truth.
Exactly what you're building at the Talking Feds YouTube, the Talking Feds Substack, and the Talking Feds podcast, and that's...
Now, let's just talk for a quick minute about YouTube. Okay. Meiselas was a member of a law firm in California. And something happened. Usually in a law firm, if you lose a big case or you cost the firm a lot of money, you kind of get politely nudged out. Something happened. I don't know what it was. But he ended up on YouTube. When all you have to do with, I guess they're near 4 million subscribers. They're making money off of most of their videos on pure advertising money alone. Just views will make money because YouTube interjects ads. And the content creators are paid a portion of those ads if they're monetized. That's how Meiselas and Meidas Touch are making their money. That's how they have people like Ron Filipkowski, as an editor-in-chief. There's, they have at least 4 people that we know of that are, on so-called on air. And they're being paid. Well, that money comes from YouTube. They think they're a newscaster. But when you're wrong, you're wrong. And you're nothing but a legal fool.